Hello and welcome back to Hood Melon Culture Studios. I am your host, Elohim the Yellow, and today we're going to be going over some more court documents in the ongoing case against Rare Breed Triggers and Thomas Allen Graves, aka TAG. Now, today we are going to be discussing the second Tulsa Graves claim chart, set aside default mail tag, and then second Tulsa exhibit CD. I think these are a little bit shorter than some of the previous documents we have gone over, so I might be able to cover them all today. If I can cover them all today, then that would be great, and I can just start releasing videos every time I get a new document from the court, and I'll be able to catch y'all up to date on everything that's happening as it's happening. Probably about a day or the day that the papers are filed or the day after, whenever they become public, just so there's no confusion. So let's get into it, shall we? Get right into it for today. We have document number 71 filed in United States District Court, ND, Oklahoma on 02/29/2024, page 1 of 8. Filed February 29th, 2024. Rare Breed Triggers against all those nonsense names, and then they're the only one we care about, Thomas Allen Graves. Case number 422, a notice of plaintiff's default for failure to respond to wrong party pro se defendants 02/01/2024 with a request for infringement, determination of the infringing party with ordered damages sought, with final disposition of case by summary judgment in favor of the non-infringing party defendants. Plaintiffs, notwithstanding the FRCP imposed plaintiff compliance with the 21-day with 5-day grace period within which plaintiff shall respond by mail, alleged defendant reasserts at this time all demands for orders sought 02/01/2024 with affidavit in support for emergency orders to compel licensee compliance to be determined as if fully incorporated herein, with further notice of plaintiff default, with further orders sought for sanctions, damages, and punitive damages, orders for lack of standing and counsel's frivolous conduct namingly a wrong party, with further demand for bench determination of the factual U.S. patent infringing party in this case, under the rule, with further ordered grant of all damages sought in favor of the infringed party, with demand for final disposition of case by the bench in summary judgment, with prejudice. Come now, I am Thomas Allen Graves, a masculine, natural living, organic man, having been maliciously, knowingly, willfully, and intentionally made a wrong party, named alleged defendant in this matter, and the court shall take judicial notice of the fatal facts of the plaintiff's case. Plaintiff lacks standing. Alleged defendant Thomas Allen Graves is a wrong party to this lawsuit. Graves as a wrong party is without adhesion to this lawsuit. Graves has never manufactured commercial firearms or firearm triggers, nor does Graves have any controlling interest in any entity doing so. Graves specializes in applied and experimental physics, including thermodynamic machine and device design. In effect, Graves is an artist and scientist, not a manufacturer, nor has he ever manufactured firearms or firearm triggers. See Exhibit 1. Electronic filing, CD disc, Graves Technologies Lab images, including reference to a website, thomasallengraves.com. Powered by Graves.com and GravesTriggerBDU.com are not nor have they ever been Graves' domain or domain name. ICANN.org may inform the court with accurate history of BDU felony, unlicensed, unauthorized use, and cyber squat violations 15 USC 1125D, 17 USC 106 and 107, copyright violations 18 USC 2320, felony counterfeit branding, use in commerce. Thomas Allen Graves Recoil Technology Systems LLC is not Graves, has never been associated with Graves, and is wholly unknown to Graves. Graves has not ever been a party to any fictitious entity operating in the firearms manufacturing industry or firearm trigger manufacturing industry. Powered by Graves Incorporated of Oklahoma is unauthorized, unlicensed infringer use of Graves' name, copyright, slogan, and exclusive right to publicity. Such use violates 17 U.S.C. 106 and 107, unauthorized use of copyright of another. Such use violates 18 U.S.C. 2320, felony counterfeit branding. All violations were known to Rare Breed Triggers to be a specific infringer, Anthony Michael McNuggets and or aka Big Daddy Unlimited or aka BDU, prior to filing and prior to the frivolous conduct of naming Graves as a wrong party in this lawsuit. Infringer and defendant infringer is not Graves and has never been owned, controlled, or operated by wrong party Graves. See compliant page 17, sentence number 75. Counsel's frivolous conduct shows they knew wrong party Graves was not and is not privy to the overall nature of Powered by Graves Incorporated. Graves is not part of Powered by Graves Incorporated or Powered by Graves. Fact, Powered by Graves TM violates wrong party Graves' exclusive rights to publicity, 17 U.S.C. 106 and 107 and 18 U.S.C. 2320. As the formation was out of Florida by another entity, Rare Breed Triggers took judgment against as the infringer in this and sister case, their master distributor. $21 million in settlement, BDU in the sister case, RBT, etc., filed exact same day as this case in NDFL, North District, Florida, to this EDOC. Plaintiff claim is not against the wrong party Graves as defendant for this reason, albeit this reason is fatal to plaintiff's claims. And case against this wrong party, alleged defendant Graves, physical flex fire technology, Starfire technology, type Alamo 15 trigger product is not owned or under the control of wrong party Graves. The plaintiffs lack standing. Whereas the plaintiffs and its counsel are in default, have not responded knowingly or purposefully. The defendant respectfully moves this court to order finding the plaintiff is in default and that the court further impose severe penalties to plaintiff's case for failure to respond to defendant's 02/01/2024 pleading and demand, and plaintiff counsel in the complaint filed to state a claim in which the alleged defendant Graves could be construed to have adhesion, association, or relationship with any other named in this case as defendant, emphasis added. And whereas plaintiffs' prior knowledge of other named defendants, Janeway, 750 Corp. Powered by Graves, unlicensed or unauthorized infringers of Graves, US 9816772, Flex Fire Technology Patent, or 772 Patent. In other words, Rare Breed Triggers and ABCDEFG are the factual 772 patent infringers and have sued, in this case, other known 772 patent infringers. Thus, those infringers then being investigated by alleged defendant Graves as being known 772 patent infringers, i.e. collective defendants in this case. Janeway, Valor, Janeway and Valor and 750 Corp. And whereas Rare Breed Triggers and ABC and counsels knew this to be fact prior to filing the EDOC, because Rare Breed Triggers and Rare Breed whatever and counsels on 10/10/22 settled sister case in the North District, Florida, 412 CB00061 with former Rare Breed Triggers exclusive distributor Big Daddy Unlimited of Florida, BDU, for reported $21 million. And whereas prior to filing suit, RBT counsels knew by at least 05/15/2022 BDU to be the infringer and not the alleged defendant wrong party Graves. Graves is the infringed IP owner. Clearly, RBT counsel's frivolous conduct in knowingly wrong party naming Graves in the EDOC case, lacking standing to do so. And whereas RBT, ABC, and counsels also knew Powered by Graves Incorporated of Oklahoma to have been created by President of BDU, Anthony Michael McNuggets. using his ownership of Blackstock Incorporated of Florida and 49% owner in BDU of Florida. All of this was known to plaintiff's counsels prior to plaintiff filing the EDOC lawsuit. And whereas RBT counsels knew prior to filing the EDOC lawsuit, all other defendants in this case, to include the instant plaintiffs themselves, are known to Graves as mass infringers of Graves' 772 patent. And whereas Janeway and Valor, 750 Corp, RBT, ABC, IP, LLC, etc., all are involved in mass infringement of Graves' 772 patent. And alleged defendant Wrong Party Graves now hereby moves this court to enter default upon plaintiffs for its failure to respond and grant all orders sought in Graves' 02/01/2024 filing for orders of indemnification owed in an amount of not less than $300,000 to fund a meaningful defense by retaining Quinn Law. And whereas for plaintiffs' failure to respond at all, therefore Graves moves the court to order severe penalty to plaintiff's case in the form of $25,000 sanction, and further order the case shall be disposed of in summary judgment after at least the plaintiff's FRT 15 trigger is examined for patent infringement and context of Graves' 772 patent claim 1 by the bench, and in compliance with under the rule governing all bench determinations of literal claim interpretations related to patent infringement. Defendant reasserts 02/01/2024 filing with orders sought 1 through 5 with affidavit in support for emergency orders to compel licensee compliance as if incorporated herein, and the entirety shall remain sought for the express purpose of finding from indemnification given in consideration to secure defendant Graves emergency relief from plaintiff's counsel's frivolous conduct in the interest of justice under doctrines of fairness. And whereas the relief sought being this court ordered specific performance by the indemnifying party, transfer of funding the requisite retainer to retain Quinn Law. Order sought for minimum of $300,000 to start uncapped, this ensuring defendant Graves per agreed contract obligation to indemnify the defendant Graves, a wrong party in this case, from RBT and malicious abuse of process lawfare. Not warfare, lawfare. It's like warfare, except in the court. A proceeding in EDOC 00107 specifically brought by RBT and cover up the fact RBT is the infringing at least Graves' 772 patent claim 1, and an admitted amount by RBT founder Mike Register of $39 million in under 24 months duration. This is admitted and agreed to under oath in the EDNY. Over 100,000 infringing units admitted to and agreed by RBT founder Mike Register and Cole Lelou in testimony given to EDNY in evidentiary proceedings as well. And whereas the EDNY determined at document 139 on 09/05/23 order the RBT units manufactured by RBT and its partner BDU that when sold hit the streets of America as government determined in 2020 and EDNY 23 CV 369 NRM RML. And I don't know what that means. And determined in order 09/05/23 at Doc 139, bench determined to be unregistered illegal machine guns. Oh, that's right. I remember when the ATF was starting to declare all that as those unregistered illegal machine gun triggers or devices. All right. C09/05/23 order by EDNY. And whereas RBT and 772 patent infringers in EDOC 00107, as well did Janeway Valor 750 infringing manufacture of illegal machine guns. And whereas this EDNY supported EODC case is extreme and exceptional, 583, 585, and inarguably caused Rule 11 irreparable harm, emphasis added, irreparable. And whereas RBT and other defendants have violated 18 U.S.C. 922 and NFA, and Whereas this rare breed triggers, EDNY determined criminal enterprise on 09/05/23 at Dock 139, has willfully, knowingly, and intentionally endangered defendant Graves and his family, endangered Graves' intellectual property, including the Core 772 patent, having a 09/11/2014 priority of invention date in the field of automatic reset triggers. Fact: rare breed triggers criminal enterprise. This determination per EDNY 23 CV 369 NRM RML findings that RBT is involved in at a minimum wire fraud, mail fraud, client conspiracy, intrinsic fraud upon consumers, and did induce manufacture, possession, offering sales of RBT's FRT 15 triggers as unregulated illegal machine guns to the streets of America, and whereas it is for this reason in 17 above that rare breed triggers FR15 triggers having been determined by EDNY courts finding are unregistered illegal machine guns in that case and banning RBT from manufacture, possession, offering, and sales of the FRT triggers as illegal machine guns. Because the same FRT15 triggers use and are marked with RBT's US 105.14223 patent or 223 patent that is used exclusively to produce illegal machine guns is before this court. Defendant Graves would believe the EDNY findings, determinations, and order had already triggered the amended judgment automatic enforceability language. In this case, that amended judgment language indicates that where the 223 patents ever become invalid or unenforceable, this judgment automatically becomes unenforceable. For this reason, the defendant believes that the amended judgment in this case is no longer enforceable. EDNY, where an EDNY determined the FRT-15 is an illegal unregistered machine gun. The same 223 patent displayed on RBT's FRT-15 triggers that are ruled as illegal machine guns in EDNY is used. I'm assuming that's Eastern District of New York, and the EDOC is like electronic document file or something like that. Frivolous conduct court case having the wrong party Graves accused of infringing said 223 patent. See now in judicial notice. It is for this reason defendant Graves did not on 02/01/24 move the court to dismiss the judgment with prejudice as part of defendant Graves' filing for specific performance on contract indemnification funding order sought as the Eastern District of New York determination left wrong party alleged defendant Graves believing the amended judgment by its language automatically unenforceable against any alleged defendant post. Partial chronology. Yep. August 5th, 2023, plaintiffs, rare breed triggers, ABC and its manufacturer, Third Gen Manufacturing. Owner Nate Evans of Logan, Utah, is seized by the government and auctioned for manufacturing patented 223 FRT-15 illegal machine guns, both 223 patented unregistered FRT-15 and Watt 15 wide open triggers, illegal machine guns. Rare breed ABC Rare breed LLC and ABC LLC unjust enrichment were exposed in the Eastern District in New York, finding of $39 million in under 24 months duration. Client conspiracy to defraud the government of $23,400,000 in federal registered machine gun tax stamp revenue due the ATF/government on minimum of 117,000 FRT-15 triggers as illegal machine guns. But I mean, we all know they're not illegal machine guns, but since they ruled this way, Graves is trying to use the previous ruling to help him out in his current case, making their filing null and void. We all know, even Thomas has told me, he's like, no, they're not machine guns. They're not machine gun triggers. That's preposterous. That's just everybody stirring up the hornet's nest to cause undue harm and unrest to everyone else around, to keep everyone running around like chickens with their heads cut off, so that the focus will be on that instead of on the infringing case of rare breed, BDU, performance triggers, etc., etc. They're just trying to cause a smokescreen so that they can get away with it and keep this case going drawn out so they can then try and bankrupt Thomas and freaking shoo him aside so that they can handle everything themselves, etc., etc., etc. So where did we leave off? On personal, yep. Gen 3, yep. 117,000 FRT triggers as illegal machine guns. September 5th, 2023. Final order findings and determination. Klein conspiracy related to FRT 15 trigger, with finding that the FRT 15 triggers and Watt 15 triggers both use the 223 patent and both triggers are determined illegal machine guns. October 27, 2023. Motion to alter judgment order for treble damages granted. October 27, 2023. Amended judgment order for treble damages granted. Motion for asset hearing. Motion is transparent. And why plaintiffs meant to, by default judgment in conjunction with entering with other purported defendants into an off-the-record, secreted, conspired, sweetheart sealed deal hidden from the defendant Graves in this lawsuit. Plaintiff meant to then strip defendant Graves of his core 772 patent or to terrorize defendant Graves to issue RBT and ABC a license to use a 772 patent. Without authorized use of Graves' 772 patent, and the FRT 15 trigger infringes on Graves' 772 patent, and likewise, any use of the 223 patent is subjective to Graves' 772 patent. RBT intended to license or take in satisfaction of $3 million amended default judgment to make RBT's 223 patent, FRT 15 triggers, and Watt 15 triggers legitimate or non-infringing in context of Graves' core 772 patent, and in hopes to take this license. No, what? I am confused. Core 772 patent, and in hopes this take or license will restore the FRT 15 trigger to legal trigger status in the EDNY court. Okay. RBT intended a subversive take of defendant Graves' 772 patent to make its illegal machine gun products 1. Legal and legitimate. 2. Uninfringing. 3. To make the FRT 15 triggers and Watt 15 triggers non-machine guns. Because if they held the original frickin' patent for the trigger technology, then it would be in plain text non-machine guns, because the government already proved this, they knew about this, and they only started declaring them illegal machine gun devices when they started mass manufacturing them under a different patent name, which is actually patent infringement. It's just a gigantic knotted mess, and all of it would go away and everybody would be allowed to have their triggers if we just settled this whole mess. But Thomas is unlikely to make any more triggers or license anyone to make triggers, because the firearms industry is filled with despicable scum who prioritize dollar bills over people's lives. So that's all y'all's fault for messing this up so badly that nobody gets anything fun anymore. So the next time y'all decide to steal and try and destroy someone's life, just don't. How about that? Just don't. So, and maybe don't try and steal the inventor's invention. Maybe pay him whatever the hell he wants and make a little bit of money because of your get-rich-quick schemes. I mean, that's exactly what this was on Rare Breed and Big Daddy Unlimited side. They're just trying to get rich quick. They don't care about fighting the ATF. The ATF is only involved because they are infringing upon Thomas's patent. So, I mean, yeah, lovely, right, you guys? Lovely. Requested Rule 11. Ordered sanction ordering plaintiff shall pay severe penalty to wrong party Graves to deter RBT and ABC IP and its counsel's future lawfare behavior and perpetuating frauds upon the judicial using abusive process to take property of others is a cog in a criminal enterprise. Yeah, rare breed triggers is a criminal enterprise that's being defended by NAGR, because NAGR, from what I understand, is just a bunch of freaking snot-nosed babies who the only thing they know how to do is file a court case. They're not freaking patriots. They don't know jack diddly about anything. They're just trying to grab more money, freaking stirring up the hornet's nest. Oh, we're in AGR. We're going to defend your rights, and you can keep them buying and selling your triggers. Yay! Even though every time a freaking ART, FRT, W, anytime any of them are sold, it's technically a crime because it's infringing stolen proprietary technology. So literally they are fighting for you to be sued and arrested by the federal government and sued by Thomas Allen Graves. If none of you knew, now you do. Oh my gosh, it angers me so much. Like, all right, get back to it. Quit being angry, don't curse, get back to it. Note, the plaintiff's grand larceny of trigger technology served to impair both Graves' lab operations, technology development, and ultimately Graves' ability to respond to rare breed triggers' malicious lawfare. The 772 patent infringement, etc., herein defined and claimed does not include the at least $100 million range subversion and theft of proprietary machines, devices, and tooling, including engines like the supercharged overhead Valve 2 stroke engine that Mazda has introduced for 2024 development, and trials using a system pioneered by Defendant Graves. Defendant Graves is not even in the picture, thus pro se. The entirety of RBT crew should be criminally referred, RICO investigated, charged, and indicted for multiple federal violations. This isn't simply about the theft of 772 patent-related prototypes, methods, and technologies. This subversion and theft is to keep Graves destitute so that he may never properly pursue these talentless amoebas. Oh, nice. See East District, New York, the Rare Breed Trigger, Wealthy Founders and Owners, Spike Tactical, Wolf Tactical, Pipe Hitters Union, LLC are finally government? Yeah, GOVT is short for government. Government targeted for client conspiracy, wire, and mail fraud meant to destroy the alleged defendant Graves by concerted Spike's Tactical founders, owners, the beneficiaries of RBT's crews. Theft of lab equipment, samples of this shown the court, followed by Spike's, Spiderhole LLC, take of $39 million in unjust enrichment in this matter of 35 USC 271 A, B, and C infringement. It is the pot calling the kettle black. To obfuscate the RBT and ABC use and abuse of this court to that end. This action, 422CV0017, is brought in RBT ABC cover-up of its theft of this trigger technology only to subvert and bastardize it, making it a machine gun. The criminal subject matter before the East District New York Court, behavior only made possible by both Rare Breed Triggers and ABCIP's unjust enrichment to fund endless lawsuits. CEDNY Doc 139. RBT founders admissions to putting 100,000 illegal machine guns on the streets of America. Actual number of units sold 400,000 plus. Verifiable through U.S. Customs and Third Gen Manufacturing, Logan, Utah. RBT's unjust enrichment by theft of method technology being $39 million realized in under 24 months duration. That unjust enrichment needs to be reapportioned by this court to the talent, in this case the defendant Graves, as a true inventor and pioneer of automatic reset trigger and the core 772 patent owner, so that the criminal enterprise RBT and crew may be brought to its knees, criminally exposed, criminally referred, and imprisoned through the bench and EDOC court. Reapportioned court-ordered partial disgorgement of RBT, unjust enrichment, ordered paid to alleged defendants. The suggested Rule 11 amount of penalty, $1.2 million USD. Note, the final amended judgment in this case, RBT has used to terrorize the Graves family, plaintiffs doing so knowingly, intentionally, and meant to purposely inflict mental anguish, stress, duress upon the Graves family in an attempt to take the Core 772 patent from the alleged defendant Graves, the WPAD, by lawfare without RBT ABC being enforced upon for its grand larceny theft from the lab, RBT, mass counterfeiting and infringement, in cahoots with the other defendants in this case, BDU, all infringers of Graves' Core 772 patent. Alleged defendant Graves is seeking exceptional case order for treble the $39 million in RBT infringement and defendant IP in unjust enrichment, then trebled to $117 million as admitted to through sworn testimony in East District, New York evidentiary hearing proceedings, stated RBT founder Mike Register and Cole Alou for filing the suit, taking amended final judgment, naming wrong party Graves as defendant for mass RBT infringement of defendant Graves' Core 772 patent. See defendant claim chart 772 versus RBT claim chart Exhibit 2, the wrong party. Named in this case a mere IP owner. See a judicial notice. This fact was known to RBT and its scurrilous counsels in this case. Alleged defendant Graves seeks this court make finding against plaintiffs, the court-ordered finding in favor of alleged defendant in this case. See now the EDNY case, doc number 139 on 09/05/2023, specifically the RBT admission to unjust enrichment of $39 million. The East District of New York determined was in fact obtained RBT fraud. Oh, wow. Further request per 35 U.S.C. subsection section 285 is alleged defendant Graves' request for defense fees and costs in an amount of $100,000 in favor of alleged defendant Graves for this abusive process case, naming a wrong party in a fire for effect fashion with disdain for the FRCP and dignity of this court. This case is exceptional. The infringer is obvious. Possible summary judgment may be had in this case by review under the rule after at least the plaintiff's FRT 15 trigger is examined for patent infringement in context of Graves 772 patent claim 1 by the bench and in compliance with and under the rule governing all bench determinations of literal claim interpretations related to patent infringement, issues, ordered penalties, and sanctions. Wrong party, alleged defendant, a mere IP owner, alleged defendant would believe appropriate in this instant case. This conduct does not stray from that shown by the East District, New York findings and determinations as to the true ilk of the RBT criminal enterprise. Simply said, RBT ABC cannot overcome Graves' Core 772 patent. This is partially why RBT desperately needs Graves' Core 772 patent or license thereof for an unjust take plaintiffs need now, more than ever, to keep defendants' Graves unfunded for litigation as the government and EDNY close in after having determined RBT to have sold an admitted 100,000 illegal machine guns to the streets of America. RBT sees it as priority to keep this wrong party defendant Graves unfunded to fight. Well, RBT can go shove it right up their keister because I'm freaking working overtime and freaking taking on some side gigs, and I'm gonna freaking fund Graves' fight against Rare Breed if I have to, because I don't see anybody else doing it, and we all seriously really need to, because this is just one gigantic conspiracy that needs to be flushed down the toilet, and freaking have that toilet thrown into a landfill, and then have that landfill loaded onto a rocket, and have that rocket shot directly into the mother effing sun. Blah. Conclusion. This court, by rule, after at least the plaintiff's FRT 15 trigger is examined for patent infringement in context of Graves 772 Patent Claim 1 solely upon the literal claim, see Exhibit 2. Proposed order for penalty to case. Summary judgment in this case in favor of wrong party alleged defendant Graves having been victimized, moreover terrorized by plaintiff's crew and plaintiff unethical counsels, the counsels for knowingly selling frauds upon the court by falsely claiming infringement by wrong party Graves, a mere IP owner. See at judicial notice. Claiming multiple frauds upon this court using lawfare, abuse of process by naming purposefully and knowingly naming a wrong party. Defendant in this malicious, frivolous counsel conduct, falsified claim of infringement prosecution. As penalty to and for unethical counsel's frivolous conduct, this wrong party Graves seeks case disposition via summary judgment after determination made by the bench under the rule governing. Alleged defendant and IP owner only Pioneer Inventors seeks orders prior to summary judgment in this case. Included therein ordered punitive damages, and amounts that shall send a message to all RBT players. Send a message to all RBT players, founders, owners, and employees in the RBT, a federal government and East District New York court-determined criminal enterprise. See document 12923 CV 369 NRM RM. The 149-page order document 139, the court's documented history of CR Enterprise RBT, infringers of U.S. Patent 772. In keeping with rules of infringement in this case, the wrong party defendant Graves seeks normal and customary full and final disgorgement of all cash triggers and all unjust enrichment. The amount sought in this case, the amount admitted and agreed to in the ED&Y court being $39 million, taken in under 24 months. Clearly, the case is exceptional. Thus, wrong party defendant Graves seeks an order for treble the damages. The same treble was granted to plaintiff when the shoe was on the other foot. Wrong party, in this case, seeks other damage amounts in addition to the $117 million and all other consideration as the court may deem good, appropriate, fair, equitable, and equity. Punitive damages sought. Punitive damages sought in the amount of $100 million be imposed by order upon all individuals, their proxies, as well as all fictitious entities and their proxies having been involved in rare breed triggers infringement of Graves' Core 772 patent. Those individuals known to alleged defendant Graves at this time and identified to date being Stephen Cooper Rounds, Texas, Jeffrey Cooper Rounds, Texas, Michael Register, Florida, Angela Register, Florida, Cole Lalou, Florida, Kevin C. Maxwell, Florida, Larry R. Lee Jr., a.k.a. Lawrence DeMonico, Florida and Texas. Lawrence DeMonico, hey Larry, you're going to prison, haha! Tony Michael McNuggets, Florida, Sherry McKnight, Florida, Chris Rios, Florida, Doug Rios, Florida, Omar Zumot, Jordan, and Florida. And oh, no, that's not an and sign. That's the directly associated with sign. The on time freaking called the and sign, but it means directly associated with. And 55 to be determined others. And there's a lot of people trying to steal from Graves. Alrighty then. Affidavit. Affidavit of I am Thomas Allen Graves, the masculine, natural, living, organic man, hereby deposes and says: 1. Plaintiffs failed to answer, period. Plaintiffs in this case are infringers of U.S. Patent 772. Plaintiff need either to own or license to use 772 to produce legal triggers. Plaintiff subject matter, the FRT 15 and 223 has been previously determined in and by the North District, New York court to have sold a minimum of 117,000 illegal machine guns and to be in possession of large cache of illegal machine guns. And RBT and ABCIP LLCs are North District, New York, federally banned from the manufacture, offering, sales, or possession of any FRT-15 as well as the RBT identical Watt 15 illegal machine gun triggers. Before this court, EDOC 422 CV 00107 as of September 5th, 2023, produce illegal unregistered machine guns. Given in truth over my hand under penalty, your affiant further saith not. Thomas Allen Graves, Executor. Notary Thomas Allen Graves appeared before me this 29th day of February 2023 and signed this affidavit in front of me in my presence. D'Angelo Mitchell, notary signature. Notary Republic. Alrighty then. The invention and derivative of FlexFire technology. Is this the claim chart? It might be. Graves 9/11/2014 FlexFire technology, or Graves FFT patent, marks commercial inception of automatic reset trigger type technology, or FFT methods and apparatus. Graves invented the world's first small arm system having integrated use of automatic reset trigger technology, or Graves FFT methods and apparatus. The plaintiffs acquired September 27, 2018, 223 patent claims are not organic, but instead were maliciously derived in-house from Graves' lab during Graves' development of Graves' FFT methods and apparatus. In any case, the plaintiffs' acquired 223 patent claims could not and cannot be used commercially independent of core Graves' FFT methods and apparatus claim. Thomas Allen Graves is an Oklahoma native, Texas star artist, inventor, engineer, thermodynamic scientist, and pioneering designer of carbines, handguns, and other armaments. Working from his Buda, Texas lab beginning in 2013 and continuing, Graves produced the basis of Graves' G1 combat carbine. That's the coolest gun I have ever seen. And when Graves told me how it works, oh my freakishly goodness. It's the freaking coolest gun ever made. I want one. I want one now. I want one in the future. I want one 10 days ago. It's literally the coolest thing I've ever heard of. G1 combat carbine and related technology. Graves G1 combat carbine is the first integrated automatic trigger reset technology, or Graves FFT type armament known to exist. Graves G1 combat carbine is, or carbine, wherever you're from, is new species of an armament that uses multiple patented FFT methods and apparatus and a 2-stroke 3-cycle gas dampening recoil system or captive pulse damper. Among other new technologies, Graves began filing FFT and other related armament patents on 9/11/2014. Graves US 9816772 FlexFire technology patent has priority of invention as early as 9/11/2014. This patent describes and defines core characteristics and features including lawfully protected methods and apparatus governing all existing commercial triggers that automatically reset. Graves 772 FlexFire technology patent is a defining core technology patent in the industry of automatic reset triggers, or Graves FFT triggers. An automatic reset trigger, or Graves FFT trigger, is not dependent on an action by the user, and therefore the reset occurs automatically and independent of user action. Graves G1 combat carbine is the world's first complete small arm design that includes an integrated automatic reset trigger, or FFT trigger system. Graves FFT provides a fire control system with digital control that allows a single shot per operating cycle. FFT was devised to provide a means to more effectively defend or protect
interest at close ranges against other highly developed combat tools or systems. Graves FFT provides increased firearm safety, including a potential of increasing both rate of fire and precision of fire at higher rates of fire beyond the fundamental design capabilities of pre-existing automatic or semi-automatic small arms. Graves FFT can provide maximized firepower while substantially preventing a firearm from firing automatically in a dead operator's hand or with a single accidental or incidental trigger depression. Graves FFT is a viable and advantageous improvement above and beyond standardized semi-automatic and full automatic fire control combat systems. Graves devised Graves FFT patent methods and apparatus to provide a viable alternative to full automatic military arms by using digitally precise semi-automatic arms, or Graves FFTs to provide armed forces with a viable solution to friendly fire deaths or wounding without sacrifice of performance or rates of fire. The plaintiff's governing and core Graves FFT patent methods and apparatus claims simply and effectively includes a small arm including a trigger that is automatically reset during gun bolt movement, and that trigger automatically unlocks in battery, making the trigger ready to fire a subsequent shot. A small arm. I'm sorry, but isn't the core function of Rare Breed Triggers 223 patent, isn't their main function a small arm? Freaking being able to reset the trigger, blah, 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 blah. I mean, I believe it is. We already looked at it. We all know that that's exactly what it is. It's the locking bar, a small arm, including a trigger that is automatically reset during a gun bolt movement, and that the trigger automatically unlocks in battery, making the trigger ready to fire a subsequent shot. We have thusly read that the RBT's 223 patent is directly infringing upon Graves 772 patent. We already know this, or at least I already knew this. All of you now know this, and we're going to keep on reading. It will also become known that another way to say that this claim is a firearm having a bolt carrier that reciprocates and displaces a trigger, causing the trigger member to be forced to the set position and the bolt carrier reaching a substantially in battery position, allowing the trigger to be moved by an external force to the released position. And if my mind can comprehend that the 223 patent is infringing on the 772 patent, and I've had a freaking stroke and I can still understand it, then it shouldn't be anything less than a miracle that the rest of the country should be able to understand this too. But Rare Breed Triggers is using your hatred of the ATF to try and pit you against Thomas Allen Graves, and by doing so, he is effectively stealing your ability to ever own legally a reset trigger device, because from what we just read, the 223 patent is infringing on the 772 patent, and from everything else we read about their malicious intent and way to basically try and keep Graves in a state of eternal detriment to prevent him from defending himself anywhere at all, again, it's understandable why everyone who knows Graves, is friends with Graves, should hate every single frickin' person associated with Rare Breed Triggers, should hate every single fan of Rare Breed Triggers. We should effectively loathe every single person who is taking RBT's side, including any and every member of the NAGR, thus extending frickin' your arm out. Like, friggin', it's awful. And everyone who is supporting RBT, you guys are monsters. Frickin', we can plainly see that RBT is the infringer. Frickin', maybe y'all should help Graves fight his fight against the patent infringement of RBT and everybody else. And maybe maybe like 5 or 6 years down the road, he might frickin' have a change of heart and decide to release the triggers for everybody. But because frickin' all of you ignorant frickin' redneck frickin' Bud Light drinking morons are frickin' just rallying on the bandwagon in this witch hunt freaking against the ATF, which has been totally manufactured by Rare Breed, because none of this would have even taken place. The ATF wouldn't have gotten involved, none of it, if Rare Breed hadn't have infringed on Thomas Allen Graves' patent in the first place. If the Round brothers hadn't stolen prototype technology from Thomas's lab, literally none of this crazy, terrible would have happened or taken place. It's awful to witness, it's awful to find out about, but what's even more awful is y'all's reluctance to admit you're wrong, swallow your GD pride already, and stand on the right side of this. I want to curse like a storm right now. In Claim 1 of Graves' US 9816772 FlexFire technology patent, we find the core methods and apparatus used in all commercial Graves FFT or automatic reset trigger-based armament technology. Claim 1. A handheld finger-activated semi-automatic arm comprising a frame, a chamber face that is supported to the frame and that comprises a barrel, a trigger that is depressible to fire the arm once per operating cycle, a gun bolt that is movable with respect to the frame rearward away from the chamber, concurrent with the trigger being positively mechanically reset, and wherein the trigger is blocked from depression until up to 99% of the operating cycle. The infringing or subjective 223 patent Claim 1. A firearm having a receiver with a fire control mechanism pocket, transversely aligned pairs of hammer and trigger pin openings in sidewalls of the pocket, and a bolt carrier that reciprocates and pivotally displaces a hammer when cycled. A trigger mechanism comprising a hammer having a sear notched and mounted in the fire control mechanism pocket to pivot on a transverse hammer pin between set and release positions. A trigger member having a sear and mounted in fire control mechanism pocket to pivot on a transverse trigger pin between set and release positions. The trigger member having a surface position to be contacted by the hammer when the hammer is displaced by cycling of the bolt carrier, the contact causing the trigger member to be forced to the set position. A locking bar pivotally mounted, and it doesn't say anything about a wheel on the locking bar pivotally mounted. It just says a locking bar pivotally mounted in a frame and spring biased toward a first position in which the locking, and this is how patents work. You have to be explicitly clear in what your patent claim is doing, and if there is any deviation from that, your patent, the 772 patent, cannot infringe upon the 223 patent. It says a locking bar pivotally mounted in a frame and spring based toward a first position in which the locking bar mechanically blocks the trigger member from moving to the release position, and movable against the spring bias to a second position when contacted by the bolt carrier, reaching a substantially in battery position, allowing the trigger member to be moved by an external forces to the release position. Now, that wheel prevents all this from taking place. That wheel is not a part of their patent claim. The freaking locking bar cannot do what they are describing because the wheel prevents it from doing so. Now, they should have thought ahead in their frickin' scheme of conspiracy, of grand larceny, theft, and all this other nonsense. They should have thought ahead, but they couldn't, because in hindsight, they were just trying to copy and paste someone else's patent. But maybe if they were actually intelligent, they would have included all the different ways that this could have taken place, and in doing so protected themselves and thus allowing them to steal from Thomas Allen Graves. But they didn't, and that's why they're freaking throwing smoke or blowing smoke and mirrors, causing a diversion, because they're trying their best to steal Thomas Graves' core 772 patent technology. FFT patent claim is inseparable from and predates the 223 patent claim thesis. Literal reductive theorem: a firearm having a bolt carrier that reciprocates and displaces a trigger, causing the trigger member to be forced to the set position and the bolt carrier reaching a substantially in battery position, allowing the trigger to be moved by an external force to the release position. Equivalency within theorem: a small arm including a trigger that is automatically reset during gun bolt movement and that the trigger automatically unlocks in battery, making the trigger ready to fire a subsequent shot. Further or reductive equivalency within the theorem inaugurably equates to Core-Graves FFT patent Claim 1, or claim a handheld finger-activated semi-automatic arm comprising a frame, a chamber face that is supported to the frame and that comprises a barrel, a trigger that is depressible to fire the arm once per operating cycle, a gun bolt that is movable with respect to the frame rearward away from the chamber concurrent with the trigger being positively mechanically reset, and wherein the trigger is blocked from depression until up to 99% of the operating cycle. Synthesis: it is impossible to use 223 patent claims without using the Core-Graves FFT patent claim. The 223 patent claims simply add to Graves' FFT claim structure. The 223 patent claims cannot be made independent of the Graves' FFT patent claim. However, the Graves' FFT patent claim may be used independent of the 223 patent claims. Making variations of a truck does not keep the truck from being a truck. Making variations of Graves' FFT does not keep the Graves' FFT from being Graves' FFT. The triggers named below are commercial products that comprise or are intended to comprise a commercial application of technology governed by the core methods and apparatus Claim 1 of Graves US 9816772 FlexFire Technology Patent. The following triggers and associated technology are furthermore used to comprise a small arm, including a trigger that is automatically reset during gun bolt movement and that the trigger automatically unlocks in battery, making the trigger ready to fire a subsequent shot. Starfire V2 trigger including copies, replacement parts, and upgrades. Alamo 15 trigger including copies, replacement parts, and upgrades. Para 15 trigger including copies, replacement parts, and upgrades. FRT 15 trigger including copies, replacement parts, and upgrades. WOT Watt 15 trigger including copies, replacement parts, and upgrades. ACAR 15 trigger including copies, replacement parts, and upgrades. Atrius trigger including copies, replacement parts, and upgrades. Hoffman Super Safety trigger including copies, replacement parts, and upgrades. Claim language infringing FRT 15 trigger. Claim language US 9816772. Claim 1 FlexFire Technology Thomas Allen Graves. Infringing FRT 15 trigger evidence. See case 12CV00149RH HTC document 1 filed 09/15/2021. 1. A handheld finger-activated semi-automatic arm comprising a frame. The FRT-15 trigger is for semi-automatic AR pattern firearm that has a lower receiver or frame. A chamber face that is supported to the frame and that comprises a barrel. The FRT-15 trigger is for semi-automatic AR pattern firearm having a chamber face/barrel. A trigger that is depressible to fire the arm once per operating cycle. The FRT-15 trigger is for semi-automatic AR pattern firearm having a trigger that is depressible to fire once per operating cycle. A gun bolt that is movable with respect to the frame rearward away from the chamber concurrent with the trigger being positively mechanically reset. The FRT-15 trigger is for a semi-automatic AR pattern firearm having a reciprocating gun bolt or BCG that displaces a trigger to the reset position during rearward gun bolt or BCG movement, and wherein the trigger is blocked from depression up until 99% of the operating cycle. The FRT-15 trigger is for semi-automatic AR pattern firearm having a mechanism capable of blocking trigger depression until the firearm is in battery. Judge Frizzle, I have provided photographic and video examples pertinent to my technological capabilities and background. I want you to understand that I have multiple decades of practice in applied and experimental physics related to the thermodynamics, machines, and devices from conception to production. Exhibit 1 is an attached CD for this purpose and is similar to and may be supplemented with information available on my website, thomasallengraves.com. Whew. That was one hell of a document. Oh my goodness. Everybody, so clearly we can understand that the 223 patent is effectively infringing on Graves' 772 patent. It doesn't matter what they create. It doesn't matter what they file for a patent. Freaking the claim language that they used is effectively the same as the freaking language used in Graves' patent. They basically tried to copy and paste the claim language, but just change the words around a little bit here and there. It's preposterous to say that Graves is the infringer. It's preposterous to say that Graves should owe them any kind of money whatsoever. I'm going to make this part 3 of the video series. The video is already going to be over an hour long. I don't want y'all to freaking get annoyed or bored with it, but I'll go ahead and I might make a few more videos before I clock out today, and I'll post those a few days after I post this one. I've been at work all day. I'm tired. I need to start just getting into the habit of doing this early in the day so I can be more, what's that word? Coherent mentally. And so I'll have a better ability to articulate the understanding that I have to y'all in case there's anything y'all don't understand. Also, it would mean a tremendous amount to me if y'all could personally donate to Thomas Allen Graves to help provide funds for him to defend himself, and so that he will be able to have the money to file lawsuits against all the infringers so that he can get freaking what's owed to him, so that he can put his life back together, so that he can have enough money to put food in his belly, gas in his truck, and smokes in his pocket. No reason should he be destitute because other people are trying to steal from him. Now, if you want to donate to Graves, you can you can just direct deposit him through Zelle. I use Zelle to help him out. I've been trying to save up on overtime and doing some side gigs so I can raise enough money personally to send him so that he will be able to file cases against Rare Breed for starters and the rest of the infringers if this case doesn't get resolved soon and if they don't pay him what he is owed. Now, it would mean the world to me if y'all could help me do this. Just donate to I don't have I'll link his phone number in the description below so that you can use Zelle to direct deposit donations for him so that he is able to feed himself and or fund the attack that we need to file against Rare Breed and all the other infringers. It's the most effed up thing in the world to create one of the most revolutionizing parts of technology for the firearms industry, and then because you invented it, everyone freaking files falsified lawsuits against you saying you're infringing upon them when they are the infringers. It's nonsensical to me. This whole situation is nonsensical. How could this ever happen? It's crazy. It's crazy. But I hope you enjoyed the video, and I hope you can leave a like, you can share, you can follow, and hit that notifications bell. Hit that notifications bell below so that you will be notified whenever I release a new video. Oh my goodness. Doing this without a script and doing just one runs like that's how I prefer to do things. It's honest, it's raw. There's no BS, there's no freaking nonsense. You get the truth, you get the full story, you get everything I give you on the first run. I'm not trying to manipulate you in any sense of the way. You get the honest to God's truth right out of my mouth the first time I say it, and that's the way I prefer to do things. So if y'all could like, share, comment, subscribe, tell your friends, donate to graves, all that jazz, that would be tremendously awesome, and I'll love you forever for it. Now I'm gonna get my brain together, go drink some water or something. Like, we get dehydrated extremely quickly up here in the mountains, so I'm gonna go drink some water. I love you guys. I hope you join me for my next video. I hope this channel grows. I hope we can support graves. I hope we can take the fight to the actual infringers, and I hope we can end this form of tyranny that is being forced against Thomas Allen Graves and his family. I love you all. Good night.